Wouldn't say anything about it.
We won't do any dancing.
I could tell my kids, you can watch me on telly.
I think mine.
I WhatsApped my family this morning, and my sisters have sent some screenshots of us with me circled and an arrow. And
so what do
saying
you?
things
So
like,
how is it looking? How are you looking, Vicky? Your lipstick
can't really see, but they said Vicky's giggling a lot. She must have her phone in, because I didn't touch my phone at all through the entire hearing.
No, fine.
She types fast. One of my sisters put, and my other sister, who's a senior instructor at Defence Academy, has written, "This is much more interesting than my Zoom lecture." So they're obviously enjoying it.
I was wondering whether I should get a set of law reports. Because
Books
they're
do
now.
No. Can I make an observation? That if you are sitting in a room with all sorts of law reports on the shelves behind you, you're containing very terribly important files that you're working on.
No, but I can't have those files behind me. I'm very nervous about it. I mean, most of the files behind me now are empty anyway, because I've moved all the files.
How you doing?
X versus Y.
Yes.
Our proposal.
Yeah.
Yeah.
Copies of writing Cambridge.
Brilliant.
Well done.
Yeah. Busy lunch. Have we got copies for everyone? Or?
Yes. I've got.
Thanks.
Hole punch? Anyone got a hole punch?
Sorry, I'm trying to get a hold.
Sure, there should be.
Sorry, I've got two for Karen. They want a whole bunch. I've got those for you and the judges.
Oh, sorry.
That's okay.
Oh, hang on. Am I handing out? Did you do copies for everyone?
Yes.
Okay, fantastic.
So you've got two.
So,
If you've got a whole
If you got two for you.
Oh, that's really kind.
oh,
Thank
that's
you very much
fantastic.
indeed.
Sorry,
Is that one for
I've
me?
given them out.
Yeah.
So,
I've got thanks.
yeah, okay. Do you want that back? Is that?
Have you
are those
sidelined
from
it, Martin?
judges?
Have you sidelined it, Martin?
Sidelined it.
Hole punch
That's
behind
for
those.
those
It's not probably.
I'm sure I've got a red pen on my thing.
And you're not
It's not sidelined.
You are mean.
No, I am profoundly grateful to Martin today because I have
Possible to whole bunch those for the judges.
And it does look fantastic.
I think we should, Martin, we think they should change the practice direction in the lower courts to include it.
So this becomes, someone's ready. That's really not good.
I said to it, it looks so good, but why are you doing it?
We don't have any extra tabs in the
No.
authorities fund, unfortunately.
Thank you.
Seems like we're no further forward on the American election since we started this morning.
Oh, is it that? Then no, what's the balance?
We've got to wait for a few days now.
Of course.
Are we ready?
Yes.
Quarter three.
Yes, Mr. Booth.
My Lord, I'm going to introduce, if I may, with your Lordship's permission, a further authority, which I hope will deal with the point that was raised immediately before the short adjournment.
Yes. You've told Mr. Huffman this, haven't you?
Indeed, they've got copies of been informed. I apologise that the copies are not sidelined.
Do we have this one?
Yes.
Right.
If I may just come back to that in a moment, my Lord,
Yeah.
and just, I think, probably to correct a response I gave in answer to one of your Lordship's questions this morning, which is your Lordship's question about the out-of-hours GP receiving, in effect, a blind call from someone with back pain, and it's progressing down their legs, and they've got neurological deficit down their legs. And I think the response I gave to your Lordship was that such a patient should be referred directly to an orthopaedic surgeon. I think I was in error in that response, my Lord, having reflected on the point. The point that separates Barry Hewes from that type of patient is his history of recent lumbar disc prolapse. So it's not every single patient with a suspected neurological deficit should always be referred to orthopaedics, but every patient who has Mr. Hewes' history of known lumbar disc prolapse, which is the primary cause of CES, and then by the GP over the telephone suspected CES, because the risk of CES is high, and it's the history that Dr. Tanner elicited that is important.
So not every red flag case. So that is
yes, it's a significant.
So that makes it more specific to facts of this particular case.
Indeed.
Where do we find the transcript of the telephone call between Dr. Tanner and...
in the supplemental bundle, my Lord. Towards the very back, tab...
So which colour bundle?
Charcoal.
Charcoal.
Charcoal bundle, tab 40, towards the very back.
Thank you. Because he didn't have access to Mr. Hughes' medical records as such, but he obtained some information from Mr. Hughes.
He obtained some history from Mr. Hughes.
Yes.
And on page 343, my Lord, just below the upper ring binder hole, I went to the out-of-hours surgery yesterday because I've got severe back pain, and then caused by a herniated disc just below that. Doctor prescribed me with diazepam and tramadol. It's actually done nothing to ease the pain. Not slept all night recently in the last hour, but the numbness in my bum and leg, and then how recently they start. And then towards the foot of the page, how long you had the sciatica and the herniated disc for? 10 months, but the actual pain has got worse since Wednesday. I had an epidural 3 weeks ago, and that obviously hasn't helped either. Doctor said 3 months ago, he says no, 3 weeks ago. Didn't make any difference. What's the plan with your specialist? Well, the specialist appointment is on the 26th of April, and it's getting worse. And then clearly history questions are asked about difficulty or accidents passing urine or opening his bowels about a third of the way down at 344, and then describing the numbness, left buttock and all the way down the leg. It just feels numb now, and then in the question in the area, in sort of your groin and genital area, that's the sort of numbness we're particularly interested in. Any numbness or pins and needles there, I'm sort of well, I mean, I'm holding like my testicles and that now, and that does feel numb, yeah. And where did that start? Like I say, about an hour ago. And then which hospital has been seeing you? Well, went to Hemel Hempstead yesterday. Reference made to the urgent care centre on top of 345. It will need to be an A&E department. If you're getting numbness in your genital area at this time, you'd have to go to Watford General. That's where the A&E department is. That's where they can organise an urgent scan and get you seen by an orthopaedic doctor. And that was the recommendation. And then we have the slightly bizarre section below that, when the Dr. Tanner says, I know you're in Hemel Hempstead, and so Hemel Hempstead would be easy to get to, but the urgent care centre wouldn't be helpful in that regard. So my advice for you would be go to Watford A&E, and if you want to be seen by the urgent care centre again, but despite what I'm recommending, I'm happy to book you in. So what would you prefer to do? Which seems a little bit strange, but that's the content of the call. My Lord, I seek your Lordship's permission to insert the authority of Wright and the Cambridge Medical Group from this court in 2011 EWCA Civ 669 into our bundle of authorities. I apologise, we don't have a further tab behind tab 9 in our bundle, so we may have to find a tab overnight, but if it could be inserted at the rear of the bundle. And
Well, it would be if someone had hole punched it.
Yes.
I'm sorry, my lord.
Could someone hole punch this for me, please? I don't want my lord and my lady at theirs hole punched. No. Very much. Thank you.
My Lord, this authority deals with the scenario where a defendant attempts to escape liability by asserting that the referral venue, if I put it like that, or the potential, not in this case, second defendant, has failed to treat the patient appropriately, and therefore, in effect, the same damage would have ensued. My Lord, it's a complicated case and rather involved case, but your Lordship will see towards the start of Lord Neuberger's judgment, paragraph 3. This was a case where an 11-month-old claimant contracted chickenpox in 1998, developed a high temperature and tachycardia, admitted to hospital, developed a bacterial superinfection, which the hospital hadn't diagnosed by the time of her discharge, and expert evidence established the bacteria seeded into the proximal femur, resulting in osteomyelitis shortly afterwards. She was discharged home, was clearly not very well. Mother took her to see GP, Dr. Winter of the Defendant Cambridge Medical Group, advised contact them if her condition failed to improve. Considerably worse the next day, made contact with Dr. Fellas, another GP, and Dr. Fellas failed to make arrangements for the claimant to be seen, and it was conceded at trial that he was negligent in not doing so, and that had he done so, he would, or at any rate should, have referred her to the hospital. As things turned out, when she did eventually get to hospital, she was not treated with the correct antibiotics. It's paragraph 7. It deals with the very sad history here, and so the proper diagnosis was not made until the 21st of April, and then scan showed septic arthritis, and arthrotomy and surgical drainage was performed, but that had led to destruction of the bone plate, and so she was left with a permanently unstable hip and mobility issues. Then at paragraph 8, 3 lines down, had the defendants referred her to the hospital on 15th April, as they should have done, and had she then been prescribed the right type of antibiotic, as she would have recovered, probably without the need for surgical drainage, and certainly with none of the permanent damage which she had suffered. Paragraph 9 sets out the course of the trial: negligence admitted, but denial that the GPs were liable for the permanent damage. Although the claimant had apparently notified the hospital about a possible claim, she hadn't brought proceedings against the hospital or joined it in the action, nor had there been contribution proceedings brought against the hospital. We'll see paragraph 10, Mr. Justice Mackay conducted the trial, and end of paragraph 10, the experts focused also to a large extent on the treatment which the claimant actually received after she was admitted to hospital on the 17th of April. Then over the page onto paragraph 11, the expert evidence established that had she been referred to the hospital on the 15th of April and had the hospital then treated her properly, she would probably have made a full recovery. And at paragraph 13, an excerpt from Mr. Justice Mackay's judgment, you will see that the word would appears in the last line there. She would have been so treated as to avoid permanent damage. Make it impossible for me to find the fact that it's more likely than not this should have been placed in their hands during the evening 15th April. She would have been so treated as to avoid permanent damage to her hip, but no should there. And then in terms of the arguments raised on appeal, paragraph 16, little Roman 2, the judge should not have concluded the hospital would have negligently failed to treat the claimant if she'd been referred and admitted on 15th April, as it was impermissible as a matter of law for the judge to have dismissed the claim on this ground. In any event, on the facts, the evidence did not justify the conclusion. After going through the very involved facts in some detail, if we might move forward about 4 pages to paragraph 31, my Lord. So far as causation is concerned, although it may very well have been that had it been a party, the hospital would have been held to be more to blame than the defendants, I would reject the contention that the defendant's admitted negligence did not contribute to the claimant's permanent injury. The defendant's case should be examined critically because of the obvious point that where there are successive tortfeasors, it cannot be right that each can avoid liability by blaming the other. Accordingly, where there are successive tortfeasors, the contention that the causative potency of the negligence of the first is destroyed by the subsequent negligence of the second depends very much on the facts of the particular case. In many cases where there are successive acts of negligence by different parties, both parties can be held responsible for the damage which ensues, so that the issue is not which of them is liable, but how liability is to be apportioned between them. The mere fact that if the second party had not been negligent, the damage which subsequently ensued would not have occurred by no means automatically exonerates the first party's negligence from being causative of that damage. As Lord Denning said in Lloyd's Bank and Budd, the doctrine of last opportunity is gone forever. Then at paragraph 33, much must depend on the facts and examples given in terms of timing. We'll see 4 lines from the bottom. In the former case, so requiring an operation in 10 days, the causative potency of the negligence might well be said to have dissipated by the subsequent long delay in operating and presumably egregious ineptitude on the part of the hospital, particularly when compared with the small delay which lay at his door. The position may be very different in the latter case, where although the hospital was negligent in failing to operate, there would have been much more time for it to have put things right, and it was placed under a tight schedule as a result of the medical practitioner's negligence. And then, my Lord, paragraphs 34 and 35, looking at previous authority in the context of clinical negligence, issue illuminatingly discussed by Lord Justice Laws in Rahman and Area Rose, and referred to with approval by Lord Bingham in Fairchild and Glenhaven, the asbestos case. In that case, there were successive alleged causes of the injured claimant's damage. The first alleged cause, negligence of injured claimant's employer. The first defendant in failing to take adequate precautions to prevent him from physical assault, which resulted in the injury, which was then negligently treated by the second defendant hospital trust. As Lord Justice Laws pointed out, there is a respectable argument supported by authority in favour of the proposition that later negligence by a doctor would amount to a new cause and so break the chain of causation flowing from the original accident. However, as he went on to say, it cannot be a rule of law that later negligence always extinguishes the causative potency of an earlier tort, as the ultimate test is that every tortfeasor should compensate the injured claimant in respect of that loss and damage for which he should justly be held responsible. Lord Justice Laws added that this approach should ensure that the metaphysics of causation can be kept in their proper place, as they offer no hope of the solution of the problems which confront the courts in this area. And then at paragraph 36, in the present case, I consider that the defendant's negligence was a causative fact of the claimant's permanent injury. In other words, as in Rahman, I have concluded that the negligence of the defendants and the failings of the hospital had a synergistic interaction in that each tends to make the other worse. And accordingly, it seems appropriate to proceed on the basis that both were causative of the damage suffered by the claimant. And then I do not consider that the hospital's failure to treat the claimant properly once she was admitted on 17th April was of such significance that it justifies a finding that the defendant's negligence was not causative of the claimant's injury, or indeed a finding that it broke the chain of causation between the defendant's negligence and the claimant's injury. And then at paragraph 41 over the page, my Lord, conclusion that the negligent delay in treatment which sadly resulted in the claimant's permanent injury amounted in aggregate to rather less than 6 days, of which just over 2 days was attributable to the defendant's failure to refer the claimant, and rather under 3 days attributable to the hospital's failure to treat the claimant properly. At least in the absence of special factors, I find it hard to see why the defendant's negligence should not be held to be a causative factor of the injury. Then over the page again, my Lord, looking at the question, second question arising under his head, namely whether the permanent injury was within the scope of the defendant's duty. Paragraph 45, in a case such as this, where the patient was in a deteriorating condition which required her to be urgently referred to a hospital, the risk, which ought to be within the scope of the general practitioner's duty, is that delay in diagnosis and referral may have an adverse effect on the patient's prospects of recovery. It seems to me wrong to limit the scope of that duty only to the adverse effect which would inescapably ensue if he delayed the referral to a point where permanent damage had become unavoidable. Any medical practitioner must know that prompt referral in such a case must widen the safety margin available for the patient, and that safety margins matter because all human processes are liable to human error. Quite apart from this, on the facts of this case, it seems to me that to hold the defendant's escape liability in reality would involve resurrecting the discredited last opportunity doctrine. Furthermore, to hold the defendants liable is not unfair, and it was always open to the defendants to join the hospital as a party, and had they done so, the court could have apportioned liability between the two parties. Accordingly, for these reasons, essentially the same as those given by Dame Janet Smith in paragraphs 129 to 132 below, I would reject the defendant's contention. Damage suffered by the claimant was outside the ambit of the defendant's duty. It's fair and in accordance with principle to hold the scope of duty in this case extended to the permanent injury suffered by the claimant. My Lord, the law was looked at from paragraph 56 onwards, 56 to 58 on Belitho, my Lord, and discussion around the topic. Admittedly, they're not concurrent tortfeasors, but the same tortfeasor. And then at paragraph 61 over the page again, my Lord, a similar conclusion to that which I read out a moment ago, but in relation to scope of duty and deprivation of the opportunity to be treated properly by the hospital. My Lord, just for the sake of completeness, turning to the penultimate page of this authority, paragraphs 129 to 132 are Dame Janet Smith's reasons for reaching a similar...
Well, Lord Justice Elias dissented, and
Indeed.
Lady Justice Smith reached the same conclusion by slightly different means.
Indeed. So I hope, my Lord, that deals with the query your Lordship raised before the short adjournment as to...
You'll find out in due course, won't you?
Indeed.
But the analogy with this case isn't perfect, is it? Because at the end of the day, the judge found that the trust had not been negligent.
Indeed, my lady. But in terms of she found that trust overall had not been negligent. Because there was no phone call from Dr. Tanner, there was no allegation of negligence relating to negligent handling of a telephone call at 6:15 in the morning, because it wasn't something that the trust were involved in at that point. And so that was not the point. The issue here is that the judge in this case simply looked at Mr. Langdon's evidence and what would have happened, did not look adequately at what ought to have happened.
Was it argued that what Mr. Langdon said would have happened as a matter of the practice at the hospital was negligent? Was that said or put to him in cross-examination?
My Lord,
Don't worry about the pleadings. What I want to know is, at trial, was it said that if that's what the hospital would have done, namely they'd referred to Annie, then that in itself was negligent?
you just give me a moment, my Lord. It's light grey bundle, my Lord, tab 10. And it's page 192.
Yep.
It's at C, being cross-examined by Mr. McLeish, established that Dr. Langdon wouldn't have taken the call. It was put to Mr. Langdon, I beg your pardon, that Dr. Kirkby had come on at 8 o'clock. And Mr. Langdon says it would have been a junior doctor, old money, what would have called a senior house officer. And then the question at D, in relation to that call, if someone had suspicion of cauda equina syndrome, it's a surgical emergency which requires specialist assessment. So you'd expect it to be entirely reasonable for a patient of that kind to be passed directly to orthopaedics, would you not? Answer no. And then answer about the department. And then this, if a GP has seen the patient, had a face-to-face consultation, and they feel the patient has got CES, then the patient is sent up to hospital as an orthopaedic expected patient. If they've just been triaged over the telephone or only had a telephone assessment, then they're directed to A&E to be seen by one of the A&E team. And then asked where his evidence on that is coming from, and it refers to the hospital's policy document, which had been looked at earlier. And then this between G and H, if it's just been a telephone assessment, we'd expect them to be seen in A&E first of all. Then it's put to him, assessment isn't required if CES is suspected. Top of page 193, it gives logistical reasons as to why patients try and get themselves in with CES. Then between D and E, put to him that creates inevitable delay. He said, well, the majority of patients get sent home from A&E without even being referred on because they have nothing to suggest CES. But then the question between E and F, in an emergency situation, it is going to create inevitable delays, not answer. If there was a genuine concern about a patient having CES, you would expect someone to act expeditiously. But again, reference made to the majority of patients. And then, my Lord, over the page again, 194H. History is set out. First of all, we know Mr. Hewes is not a new patient. He's a patient already known, I think, to the trust, because he had an epidural 3 weeks before that, top of 195. We also know that he was treated by Mr. Dyson and had an MRI under the care of Mr. Dyson, so he's not a new patient. He's a patient known to the Watford General Hospital. Is that fair? Answer, that's reasonable, yes. So, my Lord, in terms of the way in which the case was advanced, the judge had an obligation in our submission to look at what should have happened and not just what would have happened. And in the judgment, the judge singularly failed to do that.
Normally on causation matters, you're looking at what would have happened.
But also in the medical world, what should have happened, my Lord.
Was the judge asked to deal with this point on the basis of what should have happened as well as what would have happened?
If your Lordship would give me a moment.
Well, I think we can infer that the judge was not referred to the case of Wright.
That's absolutely correct, my lord, of course. As indeed neither were you before a few moments ago. And that's my omission. I'm looking, my lord, in the light grey supplemental bundle 2, tab 4, page 64. And factual causation, the expert evidence section. What's said above that on lay evidence was that a non-spinal consultant who was on call should recognise the CRS, should be aware that only orthopaedics could treat the condition. And so that would have been the person receiving the call. Then the expert evidence, Mr. Thorpe's evidence at 10. And at the end of that paragraph, Mr. Thorpe said it would be unreasonable for orthopaedic team to refuse the claimant if D3 had contacted them in the claimant's specific circumstances. And so in terms of the approach, there was a clear requirement to look at the expert evidence. And in the submission on page 65 at paragraph 14, the reality is the telephone call made to an SHO concerning a patient who was already an orthopaedic patient with known sciatica and disc prolapse for 10 months and saddle numbness over the last hour would and should have resulted in the referral, as Mr. Thorpe suggests, of the claimant for an orthopaedic expected patient. It's notable when he cross-examined on the point, Mr. Langdon did not seem to think it unreasonable.
Right. Thank you.
My lord, we're back with my skeleton argument on this issue. Page 7 of the skeleton, paragraph 12 is where we were. And again, my lord, there's no adequate analysis by the judge of Mr. Langdon's evidence, and indeed the illogicality and untenability of the position that it is not rational to refuse to see patients with suspected CES because an unquantified number of patients are referred with CES on an inadequate or unnecessary
It's perfectly rational. It's perfectly rational.
Well, my lord,
The resources come into it. If you have, you can agree or disagree, but it's not irrational. And it's understandable that a hard-pressed orthopaedic unit would say, well, let them have it looked at least by a qualified doctor in A&E and see whether or not this is indeed really a CES case. What's irrational about that? This is just assertion.
My lord, it's based on the expert evidence that was called at the time. And so, hence...
well, I must say...
My lord, on page
perhaps
8...
they use the word rational in a way differently from me.
My lord, on
perfectly
page...
understandable. Maybe you can criticise it as a practice.
But
anyway, let's not split hairs.
Taking that point for a moment, my lord. First of all, as I understand it, resources was not something that was raised as a significant defence here. It was simply Mr. Langdon's evidence that that would have happened. Clearly, he gave justifications for it afterwards, but in my submission, resources here is not a topic which should rear its head in any way, because it's common ground that there was an MRI scanner available, and common ground that Mr. Langdon was available to conduct the surgery himself until 1440. So, my lord, in terms of where the judge erred in her approach, at page 8 of our skeleton, paragraph 13,
yep.
Really, the judge should have gone to the expert evidence and looked at the views of Mr. Thorpe and Professor Fairbank as to exactly what ought to have happened at that time. The position, my lord, in paragraph 15, Professor Fairbank was of the view that pathway depended on local custom and admission via A&E was widely practiced. Mr. Thorpe maintained that it would be reasonable to see the claimant directly in A&E as an orthopaedic expected patient. And Mr. Thorpe also relied on the defendant's own policy contemplating direct GP referrals to orthopaedics for patients with suspected CES. My lord, it may be a convenient moment just to look at the first defendant's own policy, which is in the charcoal bundle, tab 41 towards the back. My lord, this was a document which certainly until trial appeared to be a trust policy dated September 2011 on page 347, so 6 months prior to these events. And there was no doubt on the part of the appellant about its applicability until Mr. Langdon gave evidence. And we see the policy applies to patients with spinal symptoms/pathology who attend the accident department or are referred for acute admissions via outpatients or following direct referral from their GPs. And we see number 2 there, acute disc hernia, including cases of cauda equina syndrome. Aims of the policy to provide a safe environment for patients whose neurological condition has the potential to deteriorate in admission and delivery of appropriate surgical care, with particular regard to cases of acute cauda equina syndrome. And then over the page on 347, at the top, the admitting doctor should inform the on-call or duty.
I do hesitate,
of course,
to rise, and I just want to flag up that the evidence at the trial was that this policy never came into play and was essentially disowned by Dr. Langdon, and that's dealt with by the judge. So I don't wish to interrupt. I don't know if I can refer to it, but it's inappropriate for it to be described as a policy in force at the trust. I obviously don't act for the trust, but that was our understanding.
That is my understanding as well.
I think that's referred to in the judgment, isn't it?
It is.
Yes.
My lord, what the judge said in the judgment was she recited Mr. Langdon's evidence that the policy had not been ratified, and that evidence was given for the first time at trial. And indeed, Mr. Langdon said, well, although I'm named as a co-author, I wasn't a co-author because I only started at the trust at around this time, so I didn't actually have any input into producing the policy. And so that was the position. However, also Mr. Langdon gave evidence that there were issues with the policy because of, in essence, being called too often in relation to patients with suspected CES. And so, my lord, it was certainly, until Mr. Langdon gave evidence at trial, thought to be a document which was in force. That clearly changed with Mr. Langdon's evidence at trial. And we can see on page 347, my lord, that advice was given with regard to cases of acute cauda equina syndrome, specifically number 1, the on-call consultant must be informed as soon as this diagnosis is suspected, and number 2, an urgent MRI scan is required. And then number 3, if an MRI scan is performed at Watford, either Mr. Langdon or Mr. Dyson and the SPR attached to the spinal team should be informed at the earliest opportunity. And then
was there evidence that this document had been circulated within Watford General Hospital?
My lord, yes, because it came from Mr. Langdon that it had caused a problem, it had caused an issue. So there was some evidence of its circulation.
All right.
But in terms of ratification...
Your turn will come.
Mr. Langdon said it had not been ratified. Now, my lord, clearly Mr. Thorpe, the appellant's orthopaedic expert, relied quite heavily on that policy in forming his opinion. And certainly it of course, influenced the allegations of negligence advanced against the trust. The author of the policy was Mr. Dyson, who was Mr. Hewes' treating consultant, and the orthopaedic experts dealt with the question of referral to A&E in their joint statement. And you have that, we're in the same charcoal bundle, tab 23, page 255. At the top on 255, question 12 was asking, would it have been reasonable and logical for any member of the orthopaedic team, if contacted by the third defendant, to refuse to accept the claimant to orthopaedics and to tell the GP to send the claimant to A&E for assessment? Professor Fairbank, this depends on local custom and practice and facilities for acute admissions. In his view, admissions of the claimant's type via ED or A&E are widely practiced. Mr. Thorpe, had the referral come directly to the orthopaedic team, it would be reasonable for them to see the claimant directly in the emergency department as an orthopaedic expected patient. This is a common practice across many admitting orthopaedic units in the UK, also reflected in the local custom and practice in the admitting policy document, where it describes referrals for admission arriving from A&E, outpatient clinics, or from GPs directly. Given that policy, it would be unreasonable to refuse an admission as an orthopaedic expected patient in this circumstance. And then at question 13, their opinion does not change depending on the timing of such a call or any particular circumstances that prevailed at the hospital on that morning.
Yes.
My Lord, quite simply, these are matters not adequately dealt with by the judge in her judgment. My Lord, of course, it's the appellant's submission that Mr. Thorpe's evidence on this matter should have been preferred, and I bear in mind your Lordship's comments earlier, but there should have been some weighing of the expert evidence on this issue. Mr. Thorpe's opinion was that referring the claimant to A&E for assessment risked delay in being seen by the appropriate specialist team, and further that Mr. Hewes did not require an examination to be accepted as an orthopaedic patient. Professor Fairbank's view was that acceptance by he didn't think acceptance by orthopaedics was mandatory, and he felt it was sensible to refer to A&E. He gave evidence that Mr. Hewes was told to go to the hospital, to the A&E department, and get them to see you. The position here in relation to Professor Fairbank is that he didn't really grapple with the issue. And when your Lordship goes back to the answer to the question, in question 12, the top of page 255 we've just looked at, it's couched as in depends on local custom and practice. But when, if the call had come in saying this chap has got a recent history of lumbar disc prolapse, had an MRI not very long ago, epidural not very long ago, getting worse, numbness in the saddle area, it's our submission that the only conclusion which could have been reached was that any reasonable and responsible orthopaedic doctor, no matter how junior, would have said, yes, send them in as orthopaedic expected, we'll see them in A&E. Well, it may be helpful just to go to the issue of follow-up for a moment, and perhaps by reference to the transcript and the light grey bundle. It's tab 11 of this bundle, and it's page 292, my Lord. This is Professor Jeremy. My lord, this is Professor Jeremy Fairbank's evidence, the first defendant's orthopaedic expert. And there's a long section of evidence given from B down to G. And really, Professor Fairbank is from D downwards giving his answer. And at F, he introduces the concept of he could have gone to a clinic. That was never an issue which you wouldn't get access to. So this is certainly our practice in my part of the world to tell people to go to A&E. No, this is widely practiced. We can differ about it. Many ways of doing it. No perfect way of managing or navigating patients with these problems through the system. And then the judge asks this. What I'm going to need to decide there, Professor, is what, if any, difference to that answer you've just given, what, if any, difference arises with a patient who has already been very recently under the care of the orthopaedic department, and whether that, therefore, in these circumstances, either Dr. Tanner wouldn't be, or otherwise hypothetically should have mandated a bypass of A&E because he was already effectively under the continuing care of the orthopaedic department. Now, my lord, that was a correct identification by the judge at that point of an issue which she had to decide, but she did not then go on to decide it in her judgment. And that's another reason why this judgment is unsound. My lord, paragraph 18.
Shouldn't we look at the way in which the expert answered the question?
Oh, of course, my lady. The top of page 293. Reference made to access to clinical records.
Well, I mean, we can
Indeed.
use it for ourselves. And the conclusion is really the last sentence at the end of the answer.
Yes, and then, my lady, just between D and E, Mr. McLeish asked the question whether or not it was mandatory for orthopaedics to accept the referral from the GP, to accept Mr. Hewes with that history. And Professor Fairbank says, well, I don't think it's mandatory. What I would say is, if I was the orthopaedic surgeon approach, say at 6 in the morning, I'd say go to A&E. That's your best chance of getting into the system. Wouldn't necessarily know what my clinics were, and then A&E can contact the orthopaedic system. The appellant challenges that approach of the expert as introducing unnecessary delay to the process, given there would need to be.
But the fact that the judge asked the question shows that she was thinking about the issue, and she got an answer from the expert.
Indeed, my lady, but it's not reflected in the judgment reached.
All right.
And just in terms of the judge's perhaps confusion and errors of fact on this point, at paragraph 54 of the judgment, my lady, end of the third line, I do accept Mr. Langdon's factual evidence that had Dr. Tanner run the A&E department between 6 and 6:30. Of course, it's never been the case that Dr. Tanner should have run the A&E department. It's the case that he should have run the orthopaedic department at the hospital. And then...
well, that must be a typo, because otherwise the sentence doesn't make sense. If you run the A&E department, on balance, or perhaps probabilities, he'd have been advised to reroute the claimant to A&E. That suggests that first reference to A&E is a mistake, doesn't it?
Well, my lady, it would appear so. But my lady, if I might turn forward to a further mistake, perhaps of more substance, paragraph 67, which is a long paragraph, it's page 323 on my copy. it's about 9 lines down on the continuation of the paragraph, page 323. The judge says this, refers to the evidence given by Mr. Langdon about advice to go to A&E, and then this, however, might involve delay due to the time of day we're concerned with, namely 8 o'clock, because at that hour the relevant junior doctor likes to be the first port of call, is usually running around a lot. I think that's an accepted error in the judgment between the parties, that it's actually 6:15 in the morning and not 8 o'clock is the time this call would have been received.
But is the judge there not dealing with the time at which the patient would actually turn up at the hospital?
It's not clear that that's the case.
What time did Mr. Hewes get to the hospital?
He got to the hospital by 8:19, I believe.
And that was 19 minutes late because the ambulances committed negligence.
Indeed.
So do we not understand the judge there to be saying, if he'd been routed to orthopaedics, he would have turned up at 8 o'clock, and the junior doctor on orthopaedics would have been running around a lot? It's not obvious to me that there's an error, in other words.
Well, I think, my lord, it was that we're in the Appendix 1 errors document that we prepared. I think it was the only accepted error, formally accepted by, but it may be have been accepted in error. We will see.
I don't think the appeal is going to hang on that particular point.
Right. Perhaps it may be helpful just to stay with the long paragraph 67.
Yes.
For a moment, just because what we can see, staying with page 323 there, in terms of Mr. Langdon's evidence, the judge notes that Theatre 1 was basically available up until 1440, just by the upper ring binder hole, because he was in charge of that theatre, and each case involved a relatively short procedure, and so the judge introduces the word hypothetically. He could have amended his list to accommodate the claimant in that theatre. Mr. Langdon really wasn't hypothetical about it at all. Further, Mr. Langdon's evidence that the patient could have been cancelled, the 1440 patient could have been cancelled to make way for the claimant right up to the point of administering anaesthesia. But again, reference to not wishing to cause distress to the booked patient. Again, in terms of the approach to factual causation, that wasn't really borne out, and the judge didn't break down the particular times sufficiently, instead dealing with factual causation solely in that single paragraph at page 78 later, and that renders the judgment unsound. My lord, if I might turn to ground 4, please. We're now concerned with the first defendant, my lord, and the ground here is that in refusing or failing to draw any adverse inferences against the first defendant, the judge was either wrong or irrational and erred both in law and on the facts. In failing to take account sufficiently or at all, there was an evidential gap in the first defendant's case, in that there was no evidence of any discussion between orthopaedics and radiology and or the radiographer prior to the MRI scan. Failing to take into account sufficiently the circumstances in which the first defendant had failed to adduce any sufficient evidence and or had failed to plead key facts subsequently relied on at trial, and failing to note the significant prejudice to the claimant in having been denied the opportunity to investigate or adduce appropriate rebuttal evidence. Of course, my lord, we refer in this section to Keith and the Isle of Man Steam Packet Company. That is really, my lord, authority for no more than the proposition that the court is entitled to draw an adverse inference in appropriate circumstances, where the gift of the relevant evidence is within the realm of the tortfeasor and therefore the claimant is prejudiced. My Lord, there are two main issues here, namely the absence of any direct evidence of discussion between orthopaedics and radiology and or the radiographer about the need for an urgent MRI scan, that coming solely from the hearsay evidence of Mr. Mackenzie as to what he would have done in usual circumstances or what his standard practice would have been. And second, there was no direct evidence of any discussion between orthopaedics and radiology or radiographer about the possibility of interrupting the MRI list or Mr. Hewes' priority within the MRI list when compared to the two numbered patients, 41336, the possible cancer diagnosis, and 41401, the cord compression. Mr. Mackenzie's hearsay evidence was that in a case of cauda equina, he would have personally gone to the radiology department to request that the list was interrupted. In fact, this MRI list was not interrupted for Mr. Hewes because Mr. Hewes came third of three in the inpatient section from 11:30 onwards. There was no evidence of any discussions about urgency or prioritisation of Mr. Hewes, and in terms of Mr. Mackenzie's assertion that the MRI scan in Mr. Hewes' case could not have taken place any quicker, that was not based upon any direct recollection of events, but upon an assumed 11:27 bleep from A&E main reception, his standard practice, and the MRI scan logging time at 11:59. As a matter of fact, Mr. Hewes was placed at the end of the inpatient list, which is not demonstrative of an inpatient list interruption or of his being prioritised. The agreed evidence of Louise Devereux, radiographer, was that 11:30 to 2 p.m. was reserved for inpatient, not urgent MRI scans, and inpatient scans. But my Lord, the position as it came to be advanced in certain questions on behalf of the first defendant during the trial was that this was the urgent scan slot between 11:30 and 2, and that rather found its way into the judge's judgment. The position, my Lord, I'm in the skeleton now at paragraph 23. And really dealing with paragraph 64(2) of the judgment.
But some urgency was shown in that he was inserted into that patient's list.
He was given an MRI scan in that list, but no, there was no evidence of interruption of the list.
No, but nevertheless, the fact is he was inserted into it.
He was.
So you're putting an awful lot of weight in where the judge put the word urgent into that sentence.
Well, my Lord, it's quite important in my submission because in terms of the direct evidence, all we have is that Mr. Hewes was scanned third of three.
Yes.
That's it.
Yes.
And so in terms of when he was a candidate for an MRI scan, namely following the assessment of Dr. Kirkby, and it seems not before he'd had his spinal x-ray here, he was inserted into the inpatient list. But in terms of the timing of that scan, what the judge says at paragraph 62, the timing of the scan, he was listed next to two other urgent cases. Timing of the scan suggests urgency and by implication dialogue by someone suitable senior with a consultant radiologist. Although this was a slot that could be used for urgent cases, it wasn't set aside as for that precise purpose. And so in terms of the two other patients, there was very little information provided to the court by the first respondent about those two other patients. And so in terms of making a value judgment as to relative urgency, the court was not in a good position. And it's our submission that the judge was not entitled to draw the inference that the claimant's scan was processed urgently just because it was included.
Do you quarrel with the judge's, what she says at 64 Roman 2 of her judgment?
My lord, yes. The word obviously is simply not borne out by the direct evidence on the point.
He was placed into the slot reserved for inpatients for whom a scan had been requested that morning, i.e. urgent cases. Do you quarrel with that?
He was clearly placed into a slot. I don't quarrel with that as an assertion, but the i.e. urgent cases is this was the inpatient list. And yes, it could accommodate urgent cases, but it was not reserved for urgent cases.
Most people who want an MRI scan often have to wait many weeks before they get it.
My lord, not in the
not in this sort of context, but
cauda syndrome.
So, all right.
But are you submitting that the judge was bound to draw an adverse inference against the defendant? Because there was no evidence about precisely how urgent the other two patients' cases were?
No, my lady.
The
judge
was that. So
the
you're
judge
not
was
submitting bound to draw an inference.
Was entitled to draw an adverse inference, and in all the circumstances here ought to have.
Well, wait a minute.
So the only reasonable conclusion was to draw an adverse inference?
No, my lord, I don't think I could go that far.
In that case, why isn't it a matter for the judge, who has the feel of the trial?
I think, my lord, because of the way in which the evidence emerged and the difficulties that the appellant experienced in obtaining information about these two other patients, the competing cases from the first defendant.
Well, then you are submitting that she was bound to draw an inference. I mean, I just want to understand what the submission is. Either she was entitled to draw an adverse inference, in which case it's a matter for her, or she was bound to draw an adverse inference, in which case we should interfere. So which is your submission?
My lady, the way it's put later on in our skeleton is that it's not appropriate for the judge to draw any inferences favourable for the first defendant. It's paragraph 32 of the skeleton. So in circumstances when gaps in the timeline relate to matters which are part of the first defendant's cases argued at trial and arose from its decisions in relation to disclosure and witness evidence, it's not appropriate for the judge to draw any inferences favourable to the first defendant. And it's our case that the inferences the judge should have drawn should have been A, that there was no discussion with the radiologist or radiographer, and B, no prioritisation of the claimant as between the three patients in the inpatient slot. But in terms of being bound to draw an adverse inference, my lady, I'm not sure I can go that far.
Right.
And we don't know much about the other two patients.
Very little, my lord, very little.
So it's not known that they, for all we know, may properly have been assessed as even more urgent than Mr. Hewes. They may properly have been assessed as not as urgent. We just don't know. Is that right?
My lord, the most information that came out at trial was that one was an apparent case of cord compression, and the other was a possible gynecological cancer case, as I understand it.
And both were that morning referrals, as it were?
Yes, they were.
So
the requests were made.
By reference to the judge's language, they also were urgent cases.
My lord, yes.
So why do you say that it should be assumed that Mr. Hewes was top of the list of those three?
Because of the critical time course in suspected CES, where time is of the essence. And so
what about cord compression or kind of who knows? I mean,
well, my lord, the answer to who knows.
I don't know. There may have been a baby involved.
The first defendant knows.
In fetus.
My lord, the first defendant knows, but that information was not provided to the claimant or to the trial. And so, we had patient numbers, but really very little else.
Was it pleaded that Mr. Hewes should have been bumped up the list in priority to the other two?
Nope.
My lord, we're in the blue bundle, core bundle. My lord, yes, page 349. The particulars of negligence, the first defendant start for page 348, top of 349. Should have arranged for urgent MRI as an emergency. MRI request form wasn't marked urgent, didn't mention CES.
Justifying
Of course, my lord.
Justifying.
Thank you. And 3.4.5, justifying interruption of the list.
I think, to be fair, you have to go on to the next page. The allegation is at 350. Little 7 is that the MRI list should have been interrupted at 09:18, which of course was a time which didn't concern these two other patients because they were in the 11:30 to 2 o'clock slot. The 09:18 is the outpatient list.
My lord, our submission is that in order to fill the evidential gap, the judge placed particular importance on Mr. Mackenzie's hearsay evidence and failed properly to take into account the prejudice caused to the claimant by the gaps in the evidence and the absence of any direct evidence from Mr. Mackenzie on key matters. And both of those factors
You say the evidential gap, but Mr. Mackenzie's evidence was designed to fill that gap.
Well,
and so they were trying to confront something that was an issue in the case. And you obviously have the point that he was overseas and couldn't be cross-examined and all that. But it was directed at a relevant issue.
I don't deny it wasn't directed at the relevant issue, my lord. It clearly was directed at the relevant issue, but it could only take the judge so far, and not as far as it did take her, in my submission.
Okay.
My lord, the page 28 of our skeleton, paragraph 28, page 12, the submission is that the judge's approach to the expert's evidence of prioritisation is inconsistent and unsound. There's criticism of Mr. Thorpe suggesting that the claimant should have priority despite knowing relatively little about the other two patients. The judge preferred Professor Fairbank's evidence as more balanced, but his evidence was internally inconsistent in that he didn't agree the other two patients should take a back seat, though acknowledged he knew very little about those two patients. His view that a factor in this was that the claimant's diagnosis of CS had not been confirmed was an illogical and unreasonable view in our submission, given this was an emergency and Mr. Hewes had suspected CES. There was no evidence before the court that the other two patients were either more serious than or equally as serious as Mr. Hewes, or indeed as time critical. And if it were the first defendant's case that those cases had priority over the claimant, then the first defendant should have adduced appropriate evidence or at least pleaded a positive case in this respect. And in the absence of the first defendant taking such steps, it was reasonable for the court to ask the judge to infer that he ought to have been prioritised. My lord, of course, the appellant was prejudiced by the inability to cross-examine Mr. Mackenzie. I'm cautious as to how I tread here, given one of the grounds permission was refused by Lord Justice McCoo. But in terms of the judge's findings, although the terminology of Mr. Mackenzie's statement was very much what he would have done, what his standard practice was. In essence, the judge at paragraph 65 and 66 accepted that he took the steps which he says he would have taken in his statement.
Cross-examination is rather difficult when a doctor, as so often happens in these cases, thinking back many years, is saying what he would have done. So cross-examination is necessarily rather limited in those situations. Well, it's different when a doctor positively says is what he did do, and then there may be more material.
It can be, my lord, but of course doctors are always assisted or not assisted by their notes or the absence of their notes.
Indeed so.
And here we don't have a note from Mr. Mackenzie until 1500 that afternoon. Correct. And so there may well have been some fertile scope for cross-examination of Mr. Mackenzie.
Well, there may have been, yes.
Indeed.
No,
One can't speculate. But equally, in terms of the approach of the judge to Mr. Mackenzie's evidence in filling the evidential gap, we say that was not reasonable in all the circumstances.
It certainly would have been fertile scope for cross-examination if Mr. Mackenzie, several years on, purported to recollect exactly what had happened. Yes.
My lord, yes. But of course, everything is circumstance dependent.
But once the judge has decided that she's going to admit the hearsay statement, isn't the weight that she gives to it a matter for her?
It's a matter for her upon hearing submissions on it, my lady, yes.
Well, this is a witness who was over the seas.
Indeed, my lord. Yeah. As indeed was one of the other witnesses in the case who flew in to give evidence from Australia.
Right.
My lord.
Anything else on adverse influence?
A little, my lord. In terms of the judge's approach to Mr. Thorpe's expert evidence and paragraph 64(3) of the judgment, clearly Mr. Thorpe accepted that the time frame from orthopaedic acceptance of logging the scan request was reasonable, but also his evidence was that it could have been done faster. And so it's our submission that, again, it's the inadequate analysis of the separate steps in the process by the judge which creates a problem for the claimant here.
But why does an analysis of the steps matter if the overall time taken was reasonable?
Because, my lady, going back to what I said this morning about the 5 steps A to E, if 5 hours would be reasonable for all the steps viewed globally and retrospectively, but if in the particular circumstances step C could reasonably and practically have been performed in 15 minutes in this hospital on this day, then 5 hours is not a reasonable overall time, 4 hours, 15 minutes.
But isn't the difficulty that your expert accepted that the overall time taken was reasonable?
I entirely accept that, my lady.
In this case?
Indeed. Okay. But that's not the complete answer, based on the way in which this case has been advanced from the outset.
I see. All right.
Well, you'll be coming back to that point, I imagine.
Yes. In terms of inferences which we say the judge ought to have drawn about what happened that morning, in particular proceeding to the MRI scan, it's paragraph 73 of the judgment. We've just looked at that, but it's quite important. I beg your pardon, we haven't looked at this paragraph, but we have in the third line the fact that Mr. Hewes was inserted into the urgent inpatient 11:30 to 2 o'clock slot demonstrates that dialogue probably played its part, when in reality, again, it's not really a demonstration of that. But then this I do not find that this constitutes a breach of duty, but in any event it made no difference in terms of factual or legal causation. There is a swift elision both in this section and in paragraph 70, subparagraphs 1 and 2 above, a melding of breach of duty and factual causation. And so a conclusion that there was no breach, but in any event, even if there was, it wouldn't have made a difference. And in our submission, it's dealt with in too short a form, given the time-critical nature of this condition. And the inference the judge should have drawn is that there was either no discussion or no reliable evidence of such a discussion between Mr. Mackenzie and radiology or radiographer. The position, my lord, paragraph 34, the judge fails to mention in her judgment the evidence given by Dr. Roffey and Dr. Kirkby that the MRI form was completed by the former. So Dr. Roffey, on the basis of his incorrect assessment that Mr. Hewes didn't have CES. If an MRI is requested for suspected CES on the basis of the wrong diagnosis, that would of course be barred or negligence. Now, no allegations were advanced against Dr. Roffey in accident and emergency, because it appeared on the face of it at the outset that the assessment by Dr. Kirkby, the orthopaedic doctor, was at 10 o'clock. Although, of course, despite 10 o'clock having been written in the notes, the judge concluded it was actually from 10:40, acceptance by orthopaedics, and then 10:50 to 11:20. And so there was actually, as it turned out, quite a large time period to be filled there, it seems, from 9:20 to 10:40, and wasn't satisfactorily filled. But clearly, during that time, Mr. Hewes was not being treated as an emergency.
I'm sorry to interrupt, but this appears to be a new allegation that there's a delay between 9:20 and 10:40, which has never been the claimant's case. And I've never seen it. It doesn't appear in the skeleton or the grounds. I'm concerned about that.
My lord, it's simply an illustration of the difficulty that the experts had in approaching this, because the factual matrix only crystallising here with the judgment, in fact, and the finding of the assessment coming between 10:50 and 11:20. And so when it's said by my learned friends that no allegations of negligence were ever made against the accident and emergency care, that was in the context of what appeared to be a reasonably swift referral from Dr. Roffey to the orthopaedic team. My lord, paragraph 35, in terms of the evidence of Mr. Langdon, we've got that set out there, and in particular the last two lines of paragraph 35, that he completely agreed that ideally they should interrupt the elective scanning list. It may be helpful just to go to that for a moment in the light grey bundle, tab 10 at page 179.
Which?
I'm sorry, light grey bundle, transcript bundle, tab 10, my lord.
Thank you.
It's just at C where the questions start. So if it's an emergency scan, the only other case that would take priority to it would be other emergency cases. Answer yes. And in relation to interrupting the list would only be interrupted in relation to prioritisation, which could be given to this emergency case and any other emergency case on the list. Is that fair? Yes. So if there are no other emergency cases on the list, then Mr. Hewes' MRI should interrupt the list, should it not, in an ideal world. And in 2012, the way the MRI service was run, they had the middle of the day set aside for doing emergency scans. Then the said by Mr. Langdon is the end there, where possible, radiologists and radiographers would have tried to get emergency scans done in that window, but I completely agree they ideally should interrupt the elective scanning list. And the elective scanning list is that which finished at 11:30. So we're talking about an earlier point in time here. And then Ms. Power rises to say, well, it's been put that it's an emergency scan. In the pleaded case, it's an urgent scan, and there's been a distinction drawn between the orthopaedic surgeon created by the orthopaedic surgeons in their joint statement, and then the point that it's an urgent scan, once diagnosis is made, becomes an emergency surgical situation, and the judge says urgent prior to diagnosis, emergency after diagnosis. Ms. Power, that certainly is my understanding of the expert view of my learned friend's pleaded case. And Mr. McLeish asks the question in a slightly different way. As time is of the essence, the requirement is to get the scan as soon as practically possible. Mr. Langdon, I would agree with the phrase as soon as practically possible. So there is no agreement by Mr. McLeish that this was the correct test, the urgent prior to diagnosis, emergency after diagnosis. He simply put the question to the expert in a different way. The requirement is to get the scan as soon as practically possible.
You say the expert. Whose evidence is this?
I'm sorry, it's Mr. Langdon. I think I know. My Lord, it's always been the appellant's case that he ought to have been prioritised in the MRI list. He was not prioritised, and this was a negligent failing on the part of the first defendant, and that where there is a gap in the evidence and where the first defendant could have adduced evidence to fill that gap but chose not to do so, the court can and should draw an adverse inference. In this case, that neither of the other two patients in the MRI list had a priority greater than the claimants.
Is that not, just before you leave that, is that not some evidence from Mr. Langdon, evidence of fact, that the scan list from 11:30 was for emergencies? Which is contrary to the point you were making earlier, that it was just the inpatient list and there was nothing urgent about it.
It was the inpatient list, but typically emergencies could be slotted into it, I think, is the nature of the evidence. I'll try and find
That's not quite what Mr. Langdon says. What he says is the way it was run at Watford was they had the middle of the day set aside for doing emergency scans.
It's page 178, my Lord.
Right.
Between D and E. They had a gap in the middle of the day where we could get emergency MRI scans done.
Thank you.
My Lord, paragraph 37 of our skeleton, the question of proceeding as quickly as practically possible. It's our submission that the judge didn't apply the correct legal test in accepting Professor Fairbank's evidence that the claimant shouldn't have had priority with respect to the MRI scan, especially when it was not yet known whether CES was confirmed. My Lord, the judgment in paragraph 75, about 2/3 of the way down, the line starting at elective and more urgent work. He accepted that theoretically Mr. Hewes could have been scanned ahead of the other two patients, but he disagreed that cancer or cord compression cases should necessarily take a back seat in such circumstances, especially where it was not yet known whether the claimant had CES. But he qualified this by observing he knew very little about those two patients. The fact that it was not yet known whether the claimant had CES is irrelevant and wholly irrelevant. The judge shouldn't have taken it into consideration in determining the urgency of this scan. And our position is quite simple, that if the scan could and should have been performed earlier. The delay is not reasonable here. The opinion evidence about a reasonable timescale is not determinative. The issue is what could and should have been achieved within the practical constraints at the time of treatment, and any delay was unreasonable within that parameter. My Lord, if I might move to ground 5 and the factual causation position in relation to the first defendant. We have, of course, travelled some of this ground already.
Yeah.
The factual errors are set out at page 38. My Lord, again, they speak for themselves in many ways, but I emphasise again that paragraph 78 is insufficient judicial treatment of the issue of factual causation, given the complexity of this case and given the way in which the case was advanced from the outset. The terms of the timings, just to highlight at 38 Roman 2, at the end there, Mr. Langdon said in evidence it would be seconds to review the scan and make the decision for surgery. And you've got the reference, and Professor Fairbank also said he would accept seconds to make the decision for surgery. So the position was that if there had been the MRI put on to the PACS system and allowing 10 minutes for Mr. Langdon to review, by around 14:10 that day, had Mr. Langdon been made aware of this patient in the system with suspected CES having an MRI, that it would then have been possible to make a decision either to operate then and there or transfer to Queen Square. Of course, the appellant prays in aid Mr. Langdon's evidence that it was open to him to operate then and there, certainly until 14:40 and possibly until 15:19, when his first patient of his afternoon list was anaesthetized. Again, the judge's focus on the times was, in our submission, rather superficial, and accepting the judge doesn't have to decide every point, it is unclear exactly how the judge has reached the timings which appear in the judgment. My Lord, I'm on page 16 and paragraph 39. Mm-hmm. In terms of the times that were put forward, Mr. Thorpe said they would aim for no more than 6 hours from arrival at A&E, but most patients with suspected CES would get to theatre within 5 hours. Some could make it by 4 hours. However, the judge has arrived at her figure of 6.5 hours. It's apparent that Mr. Thorpe's evidence has not been taken into account, and no reasons are given as to why this evidence has been disregarded, or why, on the facts, the first respondent could not reasonably have achieved a shorter time. My Lord, this again, in terms of a disclosure issue, in its defence, the first respondent pleaded and maintained throughout it was not logistically possible to operate at Watford General, even if it had wanted to, because Mr. Langdon was not available to operate because he had other urgent, in quotes, cases upon which he was operating, and there were no theatres available. Even at the beginning of trial, the first respondent asserted that there were no laminar flow theatres available. My Lord, I had to ask what a laminar flow theatre was. Apparently it's a theatre where there's a special system, a laminar flow system, keeping the air as sterile as possible, so suitable for major spinal and neurosurgery. However, it became apparent with Mr. Langdon's evidence that he and the suitable theatre were in fact available, and the operation could have proceeded in the morning at Watford General, contrary to the first respondent's case. My Lord, in terms of the judge's analysis of Mr. Langdon's evidence in relation to this point, it was inadequate and a striking omission. His evidence was that if he had been aware that a possible CES patient was having an MRI scan, he would have either stood in the MRI scanner and viewed the images there, or he would have been checking packs. And the reference for that is in our light grey bundle, tab 10, 189, C to D. Just below C. If you're aware there's a patient having an emergency scan, then you would be, if you weren't doing anything, probably going up to the MRI scanner. If you're in the middle of something, keeping an eye on packs to see if the images were coming up. Question, once you've seen the scan, decision to perform surgery seconds, answer yes. And then at the foot of the page, just below G, what I would say is, I had that morning, there was an elective case in theatre, it was done by about 10 o'clock. There were then some small, orthopaedic cases done, none of which were on the table for certainly anything more than an hour. So, if I was aware of a patient and needed to access an orthopaedic and operating theatre, essentially had an operating theatre at my disposal. But if not being aware of the patient, clearly that wasn't utilised. And then at 191, between C and D, bearing in mind the trauma list, once the elective list had finished, was essentially mine. If I'd been aware of this patient earlier in the day, then yes, I would have had a theatre available to me. And that would have been Theatre 1. And then, question, you could have just taken the executive decision, yes, and parked patient 1 and dealt with Mr. Hewes, yes, up until what time? Well, I'd say until such a time we'd sent for the patient, so I was doing my parallel theatre next door, so which was 14:40. Now, in terms of further evidence, Mr. Langdon gave evidence as to timings for anaesthetic workup. Same section, page 198, between C and D. Half an hour for that. Also gave evidence as to travel times throughout the hospital, page 200. 3 to 4 minutes from orthopaedic outpatient over to radiology. And similar time to get from A&E to radiology. Maybe 4 or 5 minutes coming back the other way if you're going to the MRI scanner. And also gave evidence as to his own recent surgical timeframes for surgical decompression, which page 196, F. And these, to be absolutely fair, were more recent than the events in question. It's fair to say that Mr. Langdon had only been a consultant for 6 months at the time of these events, and so he said he may have been a little more cautious in the speed with which he proceeded, but his recent experience was satisfactory decompression within about 45 minutes of starting the operation in a very slim patient, other patient more like 2.5 hours, which was incredibly difficult. And of course, as we know, the whole procedure at Queen Square took 2 hours later that night, beginning to end. And there will be a point at which, during the procedure, when decompression could have been and probably would have been achieved. And as I said at the outset, Mr. Hewes was a tall, slim man, and therefore, in my submission, it's likely to be at the lower end. But in any event, whatever those points, the judge failed to deal adequately with these very significant factual causation points. There are no references in the judgment to Mr. Langdon's surgical timings as recorded in the theatre logs. Both of his afternoon patients involved procedures which included a laminectomy, which would have been required in this case. Laminectomy is removal of the lamina, which some orthopaedic surgeons refer to as the roof of the vertebra. So essentially the closest to the back, when you're going in from the back, if you remove the roof, it releases the pressure on the nerves. And so that's the first part of the procedure. If we just stay within the transcripts at page tab 11, page 311, beg your pardon, tab 12. No, I'm giving an incorrect reference, I'm sorry. It's not a reference that's been updated. Scratch that, my lord, for a moment. I'll try and revisit it if I can. And so, in terms of the legal test, in paragraph 42 of our skeleton on page 17, it's our submission that the judge failed to address the issue which he identified at paragraph 36, namely what reasonable times might realistically have been taken at Watford General in the context of an emergency case of CES. And again, the judge only applies a Bolam approach to the timeline as a whole. She fails to consider each stage separately and fails to consider Belitho, what should have happened.
Well, that is at the heart of your complaints.
Indeed, indeed, Mark. And it's our simple submission that the judge's failure to engage with the detailed timeline approach is an error of law. She had first to determine what, as a matter of fact, could have happened in March 2012, before then going on to what should have happened by reference to both Bolam reasonableness and Belitho, not just what timings would have been reasonable. Of course, Mr. Thorpe gave evidence from the perspective of someone in a district general hospital as to what could reasonably be expected of an orthopaedic surgeon and how quickly each step could have been taken. And where he didn't have all the factual evidence or sufficient factual evidence for him to give an appropriate opinion, he said so. Simply put, as has been the appellant's case throughout, in a surgical emergency, a timeline cannot be reasonable if it's practically possible for the necessary steps to have been achieved faster, and there was no reasonable or logical reason for them not to have been so. And for those reasons, the judge's approach to factual causation is undermined and unsustainable if the submissions to the claimant are accepted in relation to obtaining the MRI by bumping the claimant within the list. There's been no consideration by the judge of any alternative timelines. The point about Mr. Langdon's awareness we've dealt with in the evidence already. That only emerged at trial and was a very significant piece of evidence and again not adequately dealt with by the judge. My Lord, we have, I hope, not through an overabundance of detail, included at Appendix 2 three suggested timelines. The first with succeeding against the first defendant, second succeeding against the third defendant, third succeeding against both first and third defendants. I hope they're self-explanatory. I'm not going to detain the court further with them at this point. My Lord, if I might move on to ground 6, which applies to all defendants and is the significant and complex area of legal causation in this case. My Lord, the issue of causation in CES cases is always difficult, always complex, always literature heavy. And it involves an understanding and analysis of the medical literature, the experts' reports, and the clinical records. A crucial issue is establishing when the claimant progressed from CESI to CESR, but the critical factor in determining causation was when permanent bladder failure occurred. The judge, in her judgment, concentrated on pathophysiological factors, which had largely been introduced by Mr. Crocker, the first defendant's neurosurgical expert. We say failed to give proper weight to the literature and oversimplified and misinterpreted key aspects of the evidence, as a result of which her findings are unsound. My Lord, just to give by way of an overall position before getting into the nitty-gritty and the detail, which I'm afraid one has to do. The judge preferred the opinion of Mr. Crocker and Mr. Cowie to that of Mr. Mannion, the claimant's expert. Although the appellant submits that her criticisms of Mr. Mannion were unfair, her conclusion that Mr. Mannion had to concede that urinary retention played no part in the CESI definition was factually incorrect. Her analysis of the importance of anal tone and Mr. Mannion's evidence was inaccurate, and the conclusion that Mr. Mannion was apparently fixated on overflow incontinence was unfair, given the CESI, CSR definitions and their reliance on it. My Lord, there was a lack of equivalent evaluation of Mr. Crocker, whose opinion on CESR was contrary to the first defendant's pleaded case and was dependent upon outcome, who failed to answer Part 35 questions, whose primary assertion was the claimant was in CESR at 8 o'clock in the morning, who had not given any consideration to the literature in his report, no reference whatsoever, and whose definition of gross/pathological bladder distension of 621 millilitres was out of kilter with Mr. Cowie's evidence that more than a litre would be required for gross or pathological bladder distension.
Do gross and pathological mean the same thing or not?
Probably not, my lady. I was just saying, if a urologist were present, they would almost...
I think pathological just means not normal, not what you'd expect.
Yes.
And gross means something bigger.
Yes. Yeah.
So they're not equivalent concepts.
No, but they were treated as almost equivalent.
Oh, I'm not sure that's right. Well, I can see.
I may come back to that point.
All right.
Maybe it's slightly overzealous submission. In terms of the medical literature and legal causation, of course, the main issue here is that the judge concluded the case on a pathophysiological basis, choosing, in effect, to, if not ignore, then not give very much weight to the literature, even though the experts had relied on it in their joint statement. The analysis of the literature was flawed, and I'll come back to that. And the judge's pathophysiological analysis is not wholly clear, but it appears that she determined that the claimant had complete compression of his cauda equina nerves to his bladder between 1 in the morning and 5 in the morning, with nerve death by around 11 o'clock, i.e. compression and then death of all the nerve fibres to the bladder, meaning that after 11 o'clock there could be no recovery of any of the nerves, as cell death occurs within 6 hours of complete compression based on animal experiments. That's the Stevenson There are a few points to be made about this. First, this pathophysiology causation case was not the defendant's pleaded case. It was first mentioned in Mr. Cowie's exchanged report. It was expanded on at trial after the claimant's expert, Mr. Mannion, had given evidence, and the claimant was at a disadvantage in not having a chance to adduce full evidence in relation to it, a factor which the judge ignored. Secondly, there must have been complete...
Well, what should she have done to rectify that disadvantage, do you submit?
Well, my lady, I think the way in which Mr. McLeish put it to Mr. Crocker in the course of cross-examination was that his opinion was rather like an unmoored boat, given that it really was moving in different directions and not being attached to the literature in particular.
But was the point taken that this point was not open to the defendants on the pleaded case?
My Lord, I believe it was in closing submissions, and certainly in terms of the way in which the case was pleaded. I'll take you to the pleadings in a moment, if need be. But this was a claim which moved away from the pleadings. Certainly, the defendant's approach moved away from the pleadings on this key issue of legal causation. And so there was no amendment of the either defence in relation to this issue. And in our submission, it's quite dangerous for the court not to have sufficient regard to what the pleaded case is when evaluating the reliability of expert opinion advanced for the first time very close.
That goes back to the
trial.
question I asked you a moment ago, which you didn't answer, which is what do you say the judge should have done to rectify the disadvantage which you submit resulted from that course of events?
Well, my lady, the judge could have inquired as to whether the court would be assisted by any expert urology evidence. There was never any permission for expert urology evidence, but in effect, with Mr. Crocker's evidence, the bladder became the central focus of both his opinion and, in due course, the judge's findings. And the judge could have asked whether the claimant wished to recall Mr. Mannion. Now,
is it for the judge to suggest that?
indeed, in terms of
Mr. Mannion was still there.
my lady, clearly it would have been open to the claimant to seek permission to recall.
Well, so the next question is, did the claimant object to this course of events?
No, my lady.
All right, thank you.
Speaking for myself, that's reasonable. You know, when things always happen at trial, you know, counsel got to get on and make the best of it. I mean, it's very easy with hindsight, but you know, counsel got to react. I'm sure Mr. McLeish did. This is the way the evidence was coming out, and he had to cope with it.
If you, Lordship, give me a moment. My Lord, it reminds me that it was perhaps the third iteration of the defendant's case on causation by this time. But
those are side swipes.
Indeed.
But it's, you know, once a course is taken at trial reasonably, one cannot come to the Court of Appeal and say, oh, it was all very unfair. The stand has been taken for good cause. There it is.
Well, my Lord, perhaps if I move on to the actual nuts and bolts of what's wrong with the judge's findings in relation to this issue. My Lord, if the judge is right, and if the defendant's causation position is right, there must have been complete compression from 5 in the morning of all nerves to the bladder and perianal skin from nerve roots S2 to S4. which would mean that there could be no nerve function after this time whatsoever. These nerve roots also contain other motor and sensory fibres. This would mean that Dr. Roffey's examination, Dr. Kirkby's examination, and Mr. Mackenzie's examinations, as well as the examination at Queen Square, were wrong, i.e. there could not have been any anal tone or perianal despite the documented factual findings. Now, my lord, the judge explains this away on a twofold basis. First, anal tone and perianal sensation are unreliable clinical findings. But if that was correct, and detecting the existence of anal tone and perianal sensation was to be so unreliable as to be clinically irrelevant, one poses the rhetorical question, why do clinicians bother doing such examinations at all? It was also not pleaded by any of the defendants that any of those findings of those doctors were unreliable. Second, Mr. Cowie proposed that nerve fibres are of different sizes and sensitivities to pressure, which explains why bladder function is lost, but anal tone / perianal sensation maintained. But that was not the defendant's pleaded case. The claimant was not fully prepared on the point, and there was a lack of evidence on it. Further, if all of that was right coming from the defendant, the judge needed to address to what extent anal function, perianal sensation, and sexual function would have been preserved with earlier surgery, because bladder function could then not be a surrogate marker for other organ function, as Mr. Crocker asserted, i.e. it may be arguable that the claimant would not have saved his bladder with earlier surgery, but if anal function deteriorates later than bladder, earlier surgery might have saved that. The judge doesn't address that point at all. Third, my lord...
What do you say about, for example, what the judge said at 90 Roman 5 of her judgment? And commenting on Mr. Mannion's evidence.
Of course, the judge is entitled to form a view about Mr.
But for example, the judge recorded Mr. Mannion accepting that anal tone is not a reliable indication in diagnosing CES. Mr. Mannion had accepted that.
Lord,
Promoting it as a precondition.
No, it's a slightly different point, my lord. I'm clearly not making it clearly. In terms of looking prospectively, the reliability of a finding of anal tone upon digital rectal examination is not a particularly reliable marker for whether this is possible cauda equina syndrome. So that's viewed prospectively. However, looking at the issue of causation retrospectively, knowing all that we know, if the defendant's case on causation reliant on effectively cell death, nerve death and cell death is right, then there could have been no sensation felt by Mr. Hewes when the examinations were. And so that's the difficulty and in fact the technicality of the point here. And you'll see the judge approaches it in 90 Little Roman 5. Mr. Mannion's opinion put fairly and squarely that the tone was not absent then. This pointed to the claimant falling into the CESI category at this time. And you'll see that he accepted anal tone is not a reliable indication in diagnosing CES, but thought it relevant in defining progression.
And then he refers to
the Sri Kandaraja paper.
Sri Kandaraja paper. Wow.
And again,
So is Mr. Srikandarajah, is he wrong too?
my lord, that's not the way to look at it. If one,
Well, that's why I'm looking at it.
well, of course, my lord, but we can go to the Srikandarajah paper now.
But just does it follow from your argument that Mr. Srikandarajah's opinion is not open to him?
My lord, that's not a fair question.
I'm sorry, I didn't want to be unfair.
Because we are considering here an academic paper in the medical realm, and so simply because there is the judge's reliance on this particular sentence from what's a larger paper, that's not really fair, to put it to me in those terms, because in terms of the definitions, it's clear that Srikandarajah did, in terms of, it's probably best to look at the paper, my lord, because this is one of our errors.
Right.
My lord, and we deal with it, paragraph 51 of our skeleton, probably the most concise point. It's about halfway down paragraph 51 on page 79, my lord. What's said is the judge is incorrect in her interpretation of the Srikandarajah paper, as perianal sensation is distinct because the former is sensory, whereas the latter is motor. The S2 to 4 nerve roots control motor innervation to the sphincters and sensory innervation to the perianal and saddle areas. And it's in the charcoal bundle, my lord, supplemental bundle 1. If this is before we go to Srikandarajah, we're back in the larvae paper, tab 31, page 305 from the British Medical Journal.
Sorry, tab?
Tab 31 of the charcoal bundle, my lord.
Yes, got it.
Page 305, the second page of the paper.
Yeah, which we've already looked at.
We've looked at that.
Yep.
It's the table at the bottom left corner, my lord.
Oh, yes.
And motor, sensory and reflex components of lumbar and sacral roots. And here we're S2 to S4, so we're right down at the bottom of the table. Motor innervation to the sphincters, sensory innervation, perianal and saddle areas. And my lord, the expert evidence references I've got and can take you to still within this bundle, first of all, in Mr. Mannion's report, tab 13, page 108. It's paragraph 41 there. These nerves share the same proximal nerve roots, S2 to 4, located in the centre of the spinal canal, therefore vulnerable to compression. If we move forward to tab 20 and Mr. Cowie's report, page 224. And in terms of 0.5, in particular at the end there, taking into account the sacral nerves responsible for cutaneous sensation in the perineum are those which carry afferent and efferent nerve fibres responsible for bladder function. And my Lord, then tab 20, Mr. Cowie's response to part 35 questions, page 232, paragraph 3, and it's the third line down. The spinal S2, 3 and 4 segmental nerves are responsible for cutaneous sensation in the perineum and also carry parasympathetic autonomic nerve fibres responsible for contraction of the bladder wall and relaxation of the internal sphincter of the bladder. If cutaneous sensation is lost, it implies on the balance probably there'll be a parallel loss of function of the parasympathetic nerve supply to the bladder at the same time. My Lord, in terms of what Sri Kandaraja's study required, it didn't require complete perianal sensory loss for CESR, but it did require painless urinary retention with overflow incontinence, which Mr. Hewes never had. And my Lord, again, perhaps to help orientate your Lordship, in terms of the Sri Kandaraja paper, which is tab 4 of the supplementary bundle 1, the charcoal bundle. And in particular, page 326, this is a paper from 2015. So although post-dating these events can, of course, be used because it relates to causation. It's page 326, right-hand column. The last paragraph, about 5 lines down. Gleave and McFarlane stressed the importance of categorising CES into CES incomplete CSI and CES complete with urinary retention CSR. CESR describes painless urinary retention with overflow incontinence and complete perianal sensory loss. When the patient complains of CESI, the symptoms include urinary issues of neurogenic origin, including loss of desire to void, altered urinary and hesitancy with partial saddle anaesthesia. Now, what is clear is that if one goes over the page onto 327, materials and methods, left-hand column, halfway down the page, CESR is defined as painless urinary retention and overflow incontinence, plus minus complete perianal sensory loss. In terms of where Mr. Hewes fell, he did not fall within that definition. Just staying with this paper while we're on it for a moment, my Lord, on a slightly different point. On page 328, at the top of the page, you'll see table 2, bladder outcome at initial follow-up for incomplete cauda equina syndrome and complete cauda equina syndrome with retention, including timing of autonomic signs before decompressive surgery. Mr. Mannion copied this table into the joint statement of the neurosurgeons. And if one just looks at the top row in the table, so timing less than 24 hours to surgery, these are then the initial follow-up findings. So in CSI, 32 patients in this study ended up with a normal bladder at initial follow-up, 4 with an abnormal bladder. But if we move over to CESR, surgery, 10 patients ended up at initial follow-up with a normal bladder. And so just stopping there for a moment, if that's right, then it rather undermines the theory proposed by Messrs. Crocker and Cowie. And in terms of the analysis within the paper, 328 right-hand column, the top there, Gleave and McFarlane analysed 33 of their CESR cases and concluded that timing of surgery did not correlate with urinary outcome. Just given that is there, it may be sensible just to go back within this bundle to tab 25, to the paper that's referred to there. This is Gleave and McFarlane from British Journal of Neurosurgery in 1990. And in terms of the paper, this is in the pre-CESI-CESR classification days, so we haven't got as far as that yet. But if we just look over the page on 275, that you'll see at the top left side, the 33 cases of urinary retention occurred in 32 patients, and then reference to particular patients. And then this, only patients completely unable to void or who had bladder enlargement with dribbling incontinence were included. Average age of the group was 41.2, range 23 to 67. History of trauma given by 5 patients, further 5 had undergone lumbar disc surgery, previously 2 at the same level. Patients were divided into 2 groups. Group 1 consisted of 20 patients in whom the onset of symptoms was followed within 48 hours by the development of urinary retention. Group 2 contained 13 patients with a relentlessly progressive history of sciatica, ultimately culminating in bladder paralysis. Some more patient details are given. And then the results in the right-hand column there. The outcome in the 33 patients with urinary retention was classified as excellent if full bladder control was regained within 6 weeks, good if recovery was ultimately full but delayed, fair if the patient had voluntary control but suffered from stress incontinence or lack of urinary sensation, and poor if they remained incontinent. And then results given in tables 1 and 2. In the start of the next paragraph, full bladder control was claimed ultimately by 26 of the 33 patients, at 78.8%. And so in terms of the judge's failure adequately to understand and take into account that paper and the Sri Kandarajah paper, that the story is not solely about urinary retention or exactly how painless urinary retention causes someone to fall into one classification or the other. And it's clear that if the pathophysiological theory advanced by the defendant's experts were correct, there really would be no prospect of recovery once one had passed the threshold into CESR. And it's clear from the papers that that is simply not the case, that even when people have gone into CESR, it's a minority yes, but good outcomes can be achieved. So, my Lord, whilst it appears correct that many patients with painless urinary retention with overflow incontinence will have no chance of recovery and therefore can be deemed to have permanent bladder failure and can be coined CESR, it is incorrect to equate painless urinary retention without overflow incontinence as being evidence of permanent bladder failure, as the literature demonstrates. It's also noteworthy from the literature that even some of the CESR cohort can have some recovery. So even CESR does not equate to a certainty of no recovery, which must further undermine the complete compression case, as there can never be any recovery if all nerve fibres have died. My Lord, I'm conscious of the time, but the way in which the appellant says that the evidence ought to have been approached was this. The experts agreed that progression in CES is a continuum. Second, the experts agreed that CESR does not always produce a poor outcome. In that Sri Kandaraj paper we just looked at, 30% favourable outcome at surgery within 24 hours. Third, the experts agree that there is further deterioration in function after the onset of CESR. Fourth, the experts agree that the claimant did not meet the definition of CESR in the literature on which two of them have relied in their reports. The two is simply a reference to Mr. Crocker not referring to any literature in his report. Therefore, whatever precise stage he was, CES was not as established in Mr. Hewes as in those patients with CESR in the literature. He was at an earlier stage at 1500 hours on that Monday afternoon. The defendant's experts only conclude that he was CESR with the benefit of hindsight, and both of them concede that this is, per Mr. Cowie, extremely difficult, or per Mr. Crocker, impossible to establish factually. The experts all agree that Mr. Hewes was a rapid progressor, which means that time was of the essence. And therefore, with surgery at Watford General in the afternoon of the 12th of March, 9 to 10 hours earlier than decompression was done at Queen Square, and around 5 to 6 hours after he first attended A&E, the cauda equina outcome would have been substantially better. And lastly, of course, the clear evidence from the literature that patients with complete painless urinary retention do well, and that's the Gleaven-McFarlane reference I've just taken the court to. My Lord, if that's a convenient moment, I haven't quite finished on legal causation, but I hope I'll be able to wrap up pretty swiftly tomorrow morning.
How much longer are you going to be?
I would estimate, my Lord, about 20 minutes, because I think there are several more papers I need to take the court to.
You can finish your submission, stay and we'll sit on.
Thank you very much, my Lord. In terms of further papers, my Lord, the Long paper is dealt with in our skeleton, paragraph 48, Roman 3.
Yes.
By the way, I'm just conscious my 20 minutes may have been a slight underestimate. And it's looking more like half an hour, I'm afraid.
Carry on.
The DeLong paper is tab 29 of the bundle, my Lord, and the judge...
which colour? Sorry, Mr.
I'm sorry, the charcoal bundle.
Charcoal, thank you.
Tab 29.
We're still in the experts, yeah.
The judge found that Mr. Hewes did meet the definition of CESR in this paper from 2008. What's important to set out is that this paper is a meta-analysis. It's a literature search. You'll see in the methods at the top of page 291, literature search identified 27 studies. only 5 studies out of 27 allowed the comparison of urinary outcome for CESR and CESI, and the individual definitions for each study are not referred to in the paper. Reference was made to Gleave and McFarlane from 1990, and Dinning and Schaefer's definition, which you've got on 293. 293, left-hand column towards the top. Dinning and Schaefer noted the time in which placement of an indwelling catheter is required preoperatively constitutes an easily identifiable and uniform marker of disability. In these 27 papers, it was possible to define the CESR patients as those who developed a distended, paralysed bladder exhibited by clear-cut overflow incontinence or by the requirement for catheterisation. Now, here, of course, we know that Mr. Hewes was catheterised from 1445, and hence why Mr. Mannion's opinion was that 1500 was really the point from passing to CSI to CESR. The Todd paper, my lord, is from 2015 and is behind tab 35.
Just before we leave that,
Of course.
if you carry on reading that paragraph, the author or the authors of this paper acknowledge that it's not an ideal definition.
I'm sorry, my lady, I lost it a moment.
Yeah, you took us to the first bit of that paragraph,
Yes,
which refers to the placement of an indwelling catheter
yes,
as an easily identifiable and uniform marker of disability. All I'm pointing out is that they go on to say that perhaps is not an ideal test.
yes.
They simply say it's the best we can do in defining onset of full-blown CSR.
Yes, and my lady, just perhaps again staying with that page, and the left-hand column at the foot of the page, urinary function outcome. The description of urinary function outcome varies from study to study.
Well, I think if one's being legalistic, many of these reports perhaps aren't really in a position to define CESR. What they're in a position to do is to give indicia CESR.
My lord, it's difficult because CESR and CESI are creatures of the literature.
It is difficult, but this paper illustrates what I think some of the other papers say is markers of CESR are the following, and then you have them.
Indeed, indeed. My lord, perhaps the best point to go back to is the Todd paper and our skeleton at paragraph 48, 4, little Roman 4. Todd paper at tab 35.
35, yep.
From 2015. So looking at neurological deterioration in CES, saying it's probably progressive and continuous. The abstract ends with this should prompt diagnosis and surgery for all CES patients as soon as practically possible. And then reference made to, in the introduction, to perhaps sometimes arbitrary times for surgery. Then in terms of the CESI and CESR definitions here, right-hand column towards the top, CES was stratified using standard classification. We've got CESS, which you can ignore for our purposes, CESI, the incomplete CES, sphincter problems with the objective evidence of CES, bladder control retained, CESR, the paralysed insensate bladder leading to incontinence or catheterisation. Again, we say that the judge was wrong to say that the claimant met that definition of CESR here at a time before 1445. In terms of
the definition of CESI that Todd adopts includes bladder control retained.
Yeah.
Was the evidence not that bladder control had been lost by 1203?
My lord, certainly in terms of the desire to
Now, not
void.
desire, ability, because the nurse asked Mr. Hewes.
Indeed.
And he said he was unable to.
Yes, indeed.
Why do we not treat that as being a case which is not a case of bladder control retained, but is a case of bladder control lost, and therefore, according to Todd, is not a case of CESI. As I understand it, it's either CESI or CESR. It's either one or the other.
My Lord, if only it were as simple as that. Perhaps if we move to Mr. Todd's on page 332, my Lord.
Thank you.
In the right-hand column, second paragraph, about 12 lines down, a CESI patient with hesitancy of micturition can deteriorate to an insensate bladder and urethra and still be CESI. And so the...
Sorry, it's my fault. Whereabouts?
I'm sorry, my lady. Page 332.
332.
Right-hand column.
Yeah.
Second paragraph, about 12 lines down. It's a sentence, a CESI patient...
But this isn't hesitancy of micturition, it's inability.
My lady, if one reads on,
right.
With hesitancy of micturition can deteriorate to an insensate bladder and urethra and still be CESI.
Yes.
So
insensate presumably means you can't feel it.
Yeah, but the claimant didn't have, at the relevant time, 1203, he did not have hesitancy of micturition. He could not urinate. So it's not hesitancy of micturition.
My lady, that's correct.
And it's not sensate either. It's that he simply couldn't retain control.
He had no executive control of his bladder, i.e. the sphincter. So he didn't have hesitancy of micturition. He was asked whether he could urinate, and he couldn't.
Well, yes, I think that's accurate.
Right.
Well, can I ask, if one goes back to the definition on 330 of CESR,
yes,
sensate bladder. Now, I would assume, but tell me if this is wrong, that those paralysed and insensate refer to two different aspects of CESR. Insensate meaning I can't feel the need to urinate, and paralysed meaning I can't control the need to urinate. I can't control urination. Is that wrong?
My Lord, I don't think so, is the answer to that. But in terms...
So the point is, if you've lost executive control of the bladder, as I understand it, you're no longer able to control the sphincter, which means that when you're asked whether or not you can urinate, you try and you can't.
Yes.
Right.
So why did the judge err in saying that this was CESR according to Todd, where on the evidence at 1203 it was both insensate and paralysed in the sense that he could neither feel it nor do anything about it?
It may be, my Lord, that it's not my strongest point, and perhaps I should move on.
The literature is not all one way in your favour.
My Lord, as ever, helpful morsels passed from behind me, and always an advantage to someone who was doing the trial. The bladder at 1203, Mr. Crocker described as grossly distended, but Mr. Hewes was not incontinent, so at that point he had intact sphincter integrity.
But that's a different issue. That's a different issue.
I don't think that's...
The point about overflow incontinence is the bladder is so full that even though you've lost executive control of the sphincter, the pressure of the overfull bladder simply causes the urine to come out anyway. Isn't that the point?
Lady, if you give me one moment, please. My lady, if we...
Well, as I understand it, that Mr. Hewes had 600 millilitres of urine.
621, my Lord, 1203.
Which is way over the maximum whereby people need to urinate.
Well, it's not quite way over the maximum.
400 millilitres.
Typically, my Lord, yes.
So if he had normal
control.
his nerves were working, he would, number one, feel that he wanted to urinate, and number two, he would be able to. And he wasn't able to do either at 12:03. The fact that the bladder was not at that point so full that that the pressure overcame the sphincter is a different issue, isn't it?
My lady, perhaps if we turn to Mr. Mannion's evidence in the transcript,
Yeah.
which is page 333, behind tab 12.
Of the other one.
Grey, paragraph.
Light grey, I beg your pardon. The page 333, Mr. Mannion's evidence here between E and F. He presents with symptoms of cauda equina syndrome incomplete, has 2 clinical examinations, 0920, we know the other one's later now, 1050, which are consistent with him being CES incomplete. He doesn't go into urinary retention with overflow, which is the working definition of CES complete. And then it says incomplete by mistake in the answer in the second line below. He doesn't go into retention with overflow incontinence up to the point that he's catheterized. That then takes that potential piece of useful information away. And we know obviously he ends up with a very severe cauda equina syndrome, which is consistent with a CESR following the surgery that he undergoes. Now, is there any other evidence? There is from the urodynamics he undergoes in May 2012, evidence that he has stress incontinence at 400 millilitres of bladder volume, whereas we know that on the 12th, it should be of March, he didn't have any incontinence when his bladder volume was 600 millilitres. So again, it's somewhat indirect, but it's another piece of evidence there was progression and further loss of function beyond, not just the time of the bladder scan at 1200. But actually the gold standard for measuring bladder volume is to put a catheter in and measure what comes out. And my understanding is that when he was catheterised, residual volume was about 600 millilitres. That's at 1500. But in any event...
How does that help?
Well, my lady, in any event, the position of Mr. Mannion throughout, and indeed the Gleave and Macfarlane point, is that just because that sensation is lost, the desire to void is lost, does not mean it is a permanent condition. And so that's where we go back to the Gleave and Macfarlane paper and the 78.8% having a good outcome after surgery within 24 hours in urinary function terms.
Have I got this right? There was evidence of retention by 1203. Yeah. There was no overflow incontinence as such, but what could be said is that's because he was by then insensate. Well, does that not all fit?
No, my lord, because
is that wrong?
The absence of overflow incontinence is to do, on the one hand, with bladder volume, and then obviously how that progresses. And so if Mr. Mannion's evidence of about 600 mils residual at 1500 or with catheterization is correct, essentially back calculations were being done during the trial by Mr. Cowie, who works on the basis of a 56 mils per hour accumulation of urine within the bladder. So, my lord, it's in terms of the...
But overflow incontinence is not really the heart of the matter, is it? Because all overflow incontinence is a product of how full the bladder is, and that in turn it results from how much fluid the patient has drunk since the patient last urinated. So that may vary. But what overflow incontinence shows simply is that the bladder is now so distended that the pressure of the distended bladder overcomes the resistance which would normally be provided by the sphincter.
Yes.
Yeah, okay. So what's important though is when the bladder is both insensate, so you've lost the sensation that you want to urinate, and also when you are asked to urinate and you can't, because that means you've lost executive control of the sphincter.
Yes.
Right.
But that is painless urinary retention.
Yeah.
And that in itself is not a marker of movement to CESR on the literature.
All right.
It's not even indicia of CESR.
No, my lord.
Can I ask, in the judgment, paragraph 85, the judge recites what she says were agreed definitions. Now, if the experts have agreed definitions of CESR and CSR, why are we looking beyond those to the literature? Should the judge not be working off what the experts have said? Shouldn't we be looking at what the experts have said? Because what the experts appear to have said is that CSI is a case where executive control has not been lost. If that's what the experts have agreed, why is that not the appropriate test?
It's paragraph 86, my lord, which follows immediately below.
Right, but I have great difficulty understanding that. What is the difference between a biological definition and a working definition? What's the point of experts agreeing something in their joint report if in their oral evidence they say, well, I know I agreed it, but it's not the case?
My lord, I accept the force of that point. And clearly it's never satisfactory or ideal for an expert to be saying something different from an agreed position in a joint statement. But Mr. Mannion was doing his best to assist the court as clearly as possible from his significant expertise in this field and indeed engagement with the literature. And in effect, the position adopted by the judge, the pathophysiological position, was really not a position that was adequately put to Mr. Mannion when he gave his evidence.
But are you able to explain to me what paragraph 86 means? What's the difference between a biological and a working definition?
My lord, I confess that it's probably beyond this bear of little brain to explain the difference between those two. But in terms of a biological definition, it may be perhaps rather more based on the literature. And a working definition means what it says. It's a working definition practicing neurosurgeon. But in terms of the issue of incontinence, it's right to say that Mr. Mannion was taken uphill and down dale about that issue in his evidence. Unfortunately, the judge formed an adverse view about his opinion on those points. And of course, my lord, we set out in our skeleton the reasons why we say the judge was
right.
wrong.
Well, now we are at 4:30,
We are, my lord.
and you've got just a little bit more to do.
My lord, I have got a little bit more, and I imagine it would take us a little longer than would be comfortable at the moment. So if my lord, I could be permitted 20 minutes tomorrow morning, I imagine I'll be somewhat more succinct.
That's fair enough, and you've had a long day, Mr. Booth, and no doubt you want to discuss with Mr. McKeish and your clients. Whatever the cause this may say, could I ask the 60, would 10:30 tomorrow morning be all right?
Of course, madam.
That's not inconvenient to any of you.
Not at all.
No. Is that all right with you, Mr. Booth, if we start at 10:30 tomorrow?
Absolutely, madam.
Good. I like to sit a little later in these times to enable people to travel in later, but we've got to keep this case moving forward.
Should be a little quieter tomorrow, my lord, I suspect.
Maybe. Is there any particular reading any of you would like us to do overnight? Any particular reading over and above what we've read already?
No more.
Right, 10:30 tomorrow.
All right.